Sub. Tony Richeta.
Your Honors, good afternoon. Good afternoon, everyone. This is a continuation of the panel interview of candidates for the position of Associate Justice of the Supreme Court, Vice Honorable Lucas P. Bersamin, who was appointed as Chief Justice of the Supreme Court on November 28, 2018. Your Honors, for this afternoon, the candidates to be interviewed are the following. First, Court of Tax Appeals Presiding Justice Ramon Gonzalez del Rosario. Please stand, sir. And Court of Appeals Associate Justice Nina Antonio-Valenzuela. May I request both of you to please stand? Raise your right hand, please, so that I can administer the oath. Do you swear to tell the truth, the whole truth, and nothing but the truth in this panel interview by the Judicial and Bar Council? So help you God. Thank you. Your Honors, the first candidate for interview is Court of Tax Appeals Presiding Justice Ramon Gonzalez del Rosario. May I request Court of Appeals Justice Antonio Valenzuela to stay in the holding room while the interview of Justice del Rosario is being conducted.
Take your seat,
Honors.
please. Good afternoon, Justice. Attorney Cayosa, you may ask the first question.
Thank you, Mr. Chair. Good afternoon, Presiding Justice Del Rosario.
Your Honor.
Let me first give way to questions founded by ex-officio member Congressman Leachon. This is with respect to death penalty. And he asks, do you think that the current criminal justice system of the Philippines is ready and has sufficient processes to ensure that the penalty of death will only be served to those who are really guilty of the crimes?
Your Honors, please. The imposition of any penalty is always attended with some uncertainty. No one in the legal profession can really assure that he who has been convicted of any crime is deserving of the crime, rather is deserving of the penalty. Whether it is a death penalty or any other minor penalty for that matter, if the question is whether the criminal justice system or the institution could make a categorical announcement that he who would suffer the penalty is certainly guilty cannot be made. Nonetheless, Your Honor, if it is a matter of perception as to whether the death penalty is proper, I would suggest, Your Honor, that the effectiveness of the criminal justice system much depends upon the manner by which the law and the rules on the prosecution and conviction of offenders are carried out. In fact, Your Honor, if we may observe in other jurisdictions, Filipinos, individuals, foreigners, they are so obedient and compliant with the rules simply because there is certainty that he who commits a violation of the law would thereby be held accountable therefore. So it is not a question of how grave or how less grave the penalty imposed is, but rather it is a question of whether or not the government or the prosecution is able to carry out the consequence of a criminal or an act of wrongdoing.
So in your personal assessment, is it?
In my personal assessment, Your Honor, I would say that I would respond on two perspectives. Insofar as my religious belief is concerned, Your Honor, I have my own misgivings as to whether the death penalty is proper. I have always stuck to the proposition that He who gives life is the only one who could take it away. But if the death penalty is written in the legislation, I submit, Your Honor, that authority comes from above, and the authority given to those who enforce the law must simply implement what the law says. So from my point of view, from my perspective, Your Honor, if I have my choice as a Christian and there is no provision on the death penalty, I would rather not proceed with the imposition of a death penalty. But I would not like to delve into the wisdom of the law or the legislators. If it is actually incorporated in the legislation, I shall, as part of my duty in the judiciary.
Pardon me, Presiding Justice, but I was actually referring to the effectiveness of our judicial system. Does it help ensure that those who truly deserve the death penalty are the only ones meted such penalty?
Personally, Your Honor, in the different cases or the several cases I have encountered with respect to the imposition of death penalty or those upon whom death penalty has been imposed, I should say that it has been very effective. There has been no question in the past insofar as those who were imposed the death penalty has been the subject of any serious question as to the propriety of the imposition.
Thank you, Presiding Justice. Now, there is another question also from Congressman Liachon. Do you think that lowering the minimum age of criminal responsibility will actually deter or lower the crime rates involving children in conflict with the law? And the second, how should a court act proactively in protecting the interests of children from adult criminals?
Your Honors, the lowering of age on criminal liability is something that has been the subject of several debates already. But the protection of the children is something that is based on a proposition entirely different from the right of the state to protect and serve the people. It is just unfortunate, Your Honor, that there is so much focus and concentration on the children's welfare with respect to the need to restore and to reintegrate them, to reform them in society. But I submit, Your Honor, that I was once a young person. I was once 9 years old. I was once 12 years old. I was once 15 years old. I submit, Your Honor, that the accountability of anyone should not go unpunished. It is not correct to say, Your Honor, that a minor apparently proceeding on the proposition that he does not know what he is doing is always the prime focus of any legislation. When I was 9, I knew what was right and what is wrong. When I was 15, the same thing, Your Honor. The point is, a crime is supposed to be committed with a criminal intent. The focus so much is on so much on the welfare of the child without considering the impact or the consequence of the legislation insofar as the victim is concerned. Apparently, Your Honor, there is already a premise that a child does not know what he is doing, which to me, Your Honor, is somehow fallacious with all due respect. Because if that is actually an accurate proposition, then our society would have encountered so many other minors, young people, who are in conflict with the law. The mere fact that there are only isolated or few cases involving children only shows that majority of our children or of the youth knows what is right and what is wrong. So if it is a matter of deterrent, I do believe, Your Honor, that it is a matter of deterrent, and at the same time, it is going to vindicate the victims of these minor offenders. Some people think that I read in one of the articles that is so harsh to the youth to be penalized for things they commit against the law. But those people have not been victims of minors. Imagine if a minor would kill your son, your daughter, your mother. I sincerely believe that there should be some form of vindication on the part of the victim of a crime even committed by a minor. So I submit, Your Honor, that it is a deterrent.
Thank you, Mr. Presiding Justice. Now, moving on, well, in both instances, I guess you would agree that there is need for an efficient administration of justice, and that also that there is some degree of efficiency in ensuring that those who commit crimes would really be well arrested and actually put to trial expeditiously. And in the answer to the questions that we propounded in the written exam, you actually state some suggestions. No, would you care to expound on the requirement of the statement of ultimate facts, and instead that in a complaint the allegation be rather evidence-based, no, instead of a statement of ultimate facts?
Your Honor, I am proceeding on the basis of my experience as magistrate of the Court of Tax Appeals. I have noted several instances wherein the party litigant or the claimant, petitioner in fact, goes to court and then brings about so many other reasons as to why he or the petitioner could not proceed. I have this strange feeling that the case is simply being filed in order to contest what otherwise would be a non-contestable position of the government. Ordinarily, Your Honor, the conflicting claims insofar as the CTA is concerned would be a taxpayer, a party, private litigant, and the government. And what happens is that a petitioner would assail an action of the government or of the BR and at the same time is unable to proceed. And apparently, they are actually not ready on what kind of evidence that should be presented. I find it very difficult because to deny or dismiss outright an action like that may be something that would be tantamount to a denial of due process. In some instances, there are jurisprudence to the effect that the court should not be too harsh in its resolution with respect to the litigation of cases. So there are a lot of situations wherein cases are being delayed precisely because there is the statement of ultimate facts, but the evidence is not available. I wish that insofar as the complaint is concerned, it should be evidence-based. Maybe for every ultimate fact, there is already a reference to an attachment, not necessarily an affidavit, but as to what would be the nature and the evidence, the other testimonial or documentary evidence that would be presented in connection with that ultimate fact, Your Honors.
So with the indulgence of my colleagues in the council, the red light is on, but I still have two more questions. Okay, thank you. Now, in your PDS, you divulge that there are you have two accounts in Metrobank.
Yes, Your Honors.
Upon checking, our background investigation unit found that there were three actually.
They were?
There are three. Would you care to explain?
I don't have a copy of my PDS, Your Honors, but there are other pages, Your Honor, with the kind indulgence of this, of Your Honor. I think it is complete. There are other entries in other pages, Your Honors.
Perhaps we will furnish you a copy of the certification that we received so that you
Sure,
might
Honors.
want to give your explanation in writing. Okay?
Yes, Your Honors. I will do that.
And you are aware of the anonymous opposition. You know, I would call it an opposition, but in fact, it actually states several points that the writer would want the council to ask you about, but I think you have already been furnished a copy.
I received an official communication via email, Your Honors.
Okay. So have you sent us a comment on
I have prepared it and I will be submitting it immediately after this interview, Your Honor.
Okay. So my question is actually, would you want to state something in response to the questions that are propounded in the anonymous comment on your application?
Yes, Your Honors. Maybe just to set the record straight already, I cannot remember seriatim bata. The first issue pertains to whether it is proper for the presiding justice to request that promulgation of judgment wherein he has not as yet participated is proper when the presiding justice is on leave for 15 days or less. In my comment, my written comment, Your Honor, I cited actually a CTA unbank resolution to that effect. The CTA unbank resolution is to the effect that the promulgation of judgment will proceed unless one of the justices would request that the other justices or the promulgation of judgment would wait for his return. The reason is simple, Your Honor. This is the only collegial court where an appeal from a division is made to the CTA unbank itself. No other collegial court has that kind of procedure. The fact that I, for one, has requested that a promulgation of judgment where I had not as yet participated should await me is not something that is unusual in this court. We are only 9 in the Court of Tax Appeals. If 2 justices are absent, there would only be 7. In order to reverse a judgment of a division, what is necessary would be 5 votes. It is anticipated that those who actually participated in the division decision would, of course, reconfirm their position. So if a justice would not participate in the review of the appeal decision, it is going to be very difficult to have a complete review of the decision subject of appeal. 15 days or less, but definitely, Your Honor, I cannot even remember any instance when the situation called for an immediate action and I was not able to participate. What is being avoided is that when one justice is absent, 2 or 3 of them, it is possible for the court to convene en banc because en banc only requires 5 justices to convene. So in situations like that, if there are 2 or 3 justices who are absent, the remainder would only be 6. So 3 justices who originally participated in the original division can easily be able to get a reconfirmation or affirmance of the decision, which is not the best idea in a review of a decision by an appellate court. The second issue, Your Honor, is with respect to the indictment of a corporate entity. Apparently, Your Honor, there is a difference of opinion as to whether a corporation can be the subject of an arraignment. I seriously, up to this point, submit that a corporation can be charged and prosecuted. That is precisely a doctrine laid down in a pronouncement by the Supreme Court. That is the pronouncement in Singh doctrine. If the corporation under the law can be held liable for a fine, then the corporation can be prosecuted. If the corporation can be held liable for tax evasion as provided for in the National Internal Revenue Code, and there is a provision that a fine can be imposed, I submit, Your Honor, that the corporation itself is an entity separate and distinct from the other accused in a tax evasion case. Now, how can the court acquire jurisdiction over an accused? A court acquires jurisdiction over an accused, first and foremost, for the purpose of imposing the appropriate penalty is through an arraignment. If the corporation is not arraigned and ultimately the officers of the corporation passes away, or shall we say acquitted for reasons beyond reasonable doubt, there is going to be no imposition of penalty or civil liability on the part of the corporation because the corporation precisely has not been arraigned. So the problem there is which between 2 positions is proper. Is it proper for the court to arraign a corporation when that corporation, through its officers, were at the time very much willing to enter into an arraignment. In fact, there was an arraignment made. There was an agreement on the part of the accused as well as on the part of the prosecution to arraign the corporation. Let me recall, Your Honor, that under present legislation, the court, when there is a judgment of conviction, should already make a determination as to the civil liability of the accused. The civil liability of the corporation must not be taken away from the power of the court to impose. And as I have elucidated, I seriously doubt if the court can impose the appropriate penalty or the appropriate imposition of civil liability if at the end of the day the corporation would say, I am not supposed to be a party in this case because the corporation was never arraigned. The court never acquired jurisdiction over the corporation.
And the last two issues with,
The last two issues, Your Honor, they are,
regarding the construction of your apartment.
there is no such thing as construction of my apartment, Your Honor. That is malicious and despicable, so to speak. There are two instances. The one instance is with respect to me supposedly berating people that encountered into an accident with the vehicle my driver was using. Your Honor, that happened more than 2 years ago. And the manner by which it is presented is so unfair because at that time, I was even on vacation leave. I was in Korea at the time, Your Honor. So it is practically and physically impossible for me to be a passenger in that vehicle and harassing supposedly the parties against whom my vehicle collided. With the other version, Your Honor, I seriously deny, and I am fully aware that I am under oath. There has not been any instance to that effect.
Because with respect to the repairs in your...
Yes, Your Honor.
So you...
There has been no instance when during office hours, there has been the use of official personnel of the CTA.
But outside of office hours?
I could recall one or two, Your Honor, during weekends on an emergency situation, but they are being compensated not by the court. If it is on a weekend, Your Honor, I always give them an allowance much more than that is expected of any employer.
Okay, so anyway, we will be expecting your comment. So with that, Mr. Presiding Justice, good luck. Thank you.
Thank you, Your Honor.
Thank you, Justice Mendoza. I have no further questions.
Thank you, Attorney Judicial.
Thank you, Justice Mendoza. Yes, good afternoon.
Good afternoon, Your Honor.
Justice Ramon del Rosario. How is your health, Justice?
I would assume that my health is consistent with my age, Your Honor. And with age comes wisdom.
Because according to the medical results, your hemoglobin is high, urinalysis likewise high, chest X-ray, atherosclerosis aorta, degenerate Jesus, changes of the image spine. Were you able to consult your doctor and to interpret these medical results?
Yes, Your Honor. In fact, I'm the very first one who felt very anxious when I read the result. And fortunately or unfortunately for my doctor, he has always been assuring me that there is nothing wrong and everything is simply consistent with my age. In fact, my medications are the very light ones, Your Honors.
All right, thank you. If you had to choose to live without one of your 5 senses, which one would you give up?
A very difficult question for someone who believes that all the senses were actually provided by its creator to have a complete and full life. But if not given any choice, I would rather lose my sense of hearing, Your Honor.
Why, please?
because there is an alternate mode of perception, Your Honor. Hearing is a mode of perception, and with the eyes, I would assume that I would be able to at least communicate.
Why not sense?
We are referring to five senses, Your Honor.
Yes.
And,
Smell, please.
If it is the eye, Your Honor, the world is simply too beautiful for me to miss. The colors and everything. And so
How
far
about the
as
smell?
the smell, Your Honor, is vital in the manner by which we appreciate taste, and of course the completeness of anything that is beautiful. Beauty is appreciated not only by the eyes but by the senses. That is why there is even a statement that the rose would smell as sweet, call it by any other name, meaning the smell, the olfactory perception is indeed important.
All right, thank you. Your application document have grammatical and typographical errors. Is this the way your decisions and orders will be drafted and released?
May I be clarified, Your Honor, on the grammatical errors?
Yes, please.
May I know, Your Honor, the specific portion on the PDS where the error appears?
Your letter of application dated January 22, 2019, please, starting that your credentials as Court of Tax Appeals Presiding Justice. And second to the last paragraph, attached is my updated personal data sheet and other requirements.
You see,
Is this correct?
Actually, Your Honor, I noted that, but for lack of material time, that was actually a form provided by the JBC. It is something that is downloadable, and I actually noted that, Your Honor, but if Your Honor would notice, the application was filed just a few minutes before the deadline. My only explanation to that is that is a form provided by the JBC, Your Honor. It is a downloadable format, Your Honors.
You know, in our pursuit to improve the judiciary, we refuse to shortlist those who do not know these basic matters. Why should you be an exception?
Your Honor, human as I am, I would never claim that I never commit a mistake. But one mistake should not make a man. In this particular instance, Your Honor, the supposed mistake is a mistake that emanated from no less than the form provided by the JBC. But insofar as that is concerned, I have my own set of decisions, and the court could also review the decisions. I would say, humans as I am, I see to it that there is no mistake on matters like that, particular on matters of substance. So, may I beg this council to consider that mistakes really do happen.
All right, empirical knowledge teaches us, man, that whatever you do, you must have to proofread. Am I correct?
I'm sorry, Your Honor.
Proofreading is very important.
Yes, Your Honors. I totally agree.
What do you consider your greatest accomplishment that makes you the best bet for the current vacancy in the Supreme Court?
Your Honors, I would not venture into saying that I am the best. I would rather say, Your Honor, that I have the necessary qualifications to fit in the job. I have been an advocate for the past 30 years at the Office of the Solicitor General. I have an experience in administrative matters, and I am an adjudicator, no less than a presiding justice of the Court of Appeals, Court of Tax Appeals. Your Honor, the wide range of knowledge and skill I have gained through these years, I submit, really qualify me to the position. Not everyone has the rare opportunity to really apply. And in fact, it is my proposition that since the creation of the Court of Tax Appeals, there has been no justice from the Court of Tax Appeals that has entered the Supreme Court. I would like to share my knowledge and expertise on these three aspects. I have the aspect on advocacy, administrative matter, and adjudication. And most of all, there is a specialized field that I am engaged in, which is the field of taxation.
All right, some clarifications on your SAL-N. Your 2009 SAL-N has no amounts provided for in the total real properties, total personal properties and net worth. Why?
I do not have a copy, Your Honor, but I suppose there is, Your Honor. But if there is really a necessity to respond to that, I'm sorry that I do not have a copy of the SAL-N. I can explain.
How about your SAL-N in the year 2010? How did you come up with the total of 5,433,100 million in real properties? Are you referring to a condo unit?
There are several properties, Your Honor. I cannot remember already the specifics, but with due respect, I can make the necessary submission. Especially during those years, there was the time that there was the settlement of estate of my father, and subsequent years, settlement of the estate of my father-in-law, and recently the settlement of the estate of my mother-in-law. There may be certain amounts that are reflected there as a consequence of the inheritance or donations coming from my in-laws, Your Honors. And with all modesty, my wife also comes from an affluent family. With all modesty, Your Honor.
Based on the face of your SAL-Ns that we have, it appears that you had such a high jump in net worth from 2 million in 2009 to 14 million in 2010. Is this accurate?
I suppose so, Your Honor. I suppose that that 2009 was the time when my father-in-law passed away. So in all probability, that could have been the result of the share that my family received upon the demise of my father-in-law.
You mean to say such increase attributes to a huge increase of 12 million?
I doubt, Your Honor, if it is actually a 12 million increase. But I will explain each and every detail if necessary, Your Honor. It's just unfortunate that I don't have a copy of my SAL-N now.
Excuse me. Do you agree with the ruling of the court in Republic versus Manalo? GR number 221029, April 24, 2018.
If my memory is still accurate, is that with respect, Your Honor, to the ruling pertaining to the provision on divorce in Japan, wherein a divorcee was able to, a foreigner in a Filipina was able to get a divorce. Is that the same case, Your Honor? Because if that is the same case, I fully agree. Because under Article 26, I submit that there is no reason to penalize a Filipina in a sense that he would not be able to marry despite the fact that there is already a divorce decree and the spouse is able to marry abroad.
My time is up. Only one question. What have you done professionally that is an experience you will not want to repeat?
I cannot, I'm sorry, Your Honor, I cannot conceive as of now anything that I have done which I have regretted. It is, in fact, it is already a cliche that people never regret for things that they do. They regret ordinarily comes on people who fail to do things they wanted to do.
All right, thank you again. That one last question. May I? If you could start your career over again, what will you do differently?
If we are talking, Your Honor, of an open career, I think I would no longer engage in the legal profession. I've always wanted to join the church. I wanted to be a priest, in fact. But things turned out differently, and everything must have happened to me because of destiny.
All right, thank you very much.
Thank you, Your Honors.
And good luck, Justice.
Thank you, Your Honor.
Thank you, Judge Silao. Justice Rosario. Good afternoon. Del Rosario, good afternoon.
Good afternoon po.
You mentioned earlier that you claimed that a corporation can be arraigned. Have you, in the Court of Tax Appeals, arraigned a corporation?
Yes, Your Honors.
And who represented the corporation?
At that time, I'm not very certain, but more or less, Your Honor, at that time, there was the president who was actually a co-accused of the corporation. So the information reads Corporation X, comma, and then other individual accused who are responsible officers of the corporation. So during the arraignment, I simply ask, you are entering a plea for and on your behalf. Would you have any serious objection if you represent the corporation in the arraignment of this case, so as not to obviate any possibility that the corporation would later on say that the court has no jurisdiction over it? And there was a full agreement, Your Honor.
So the president was asked to plea in two capacities.
Yes, Your Honor. So
as representative of the corporation and in his personal capacity.
Yes, Your Honor. In the order that I issued, I simply said that enter a plea of not guilty on behalf of the accused X and in behalf of the corporate entity as an accused.
You were looking forward in case the corporation would be fined.
Yes, Your Honor. And if the corporation, if the other accused, the individual accused, dies during the proceedings or is acquitted, I would like to ensure that the corporation cannot set up the defense that the court did not acquire jurisdiction over it.
And yes, and if the penalty is not fine, how would that be?
Your Honor, arraignment has nothing to do with the penalty. In fact, Your Honor, the arraignment is simply very relevant insofar as the acquisition of jurisdiction. There is going to be no imprisonment on the part of the corporation because that is also provided in Ching, the doctrine that I have been citing. In Ching, it is said that, of course, if the penalty is fine, the corporation could be charged. But if it is imprisonment, the corporation cannot be charged. If it is mixed, the corporation can be charged.
In your records, it appears here that you have been in the office of the Solicitor General for about 22 years. Am I accurate? Or 20?
I think it is 30 years, Your Honor.
30 years? Oh, I see. What were the cases that you handled?
Actually, Your Honor, I handled special cases on money laundering, the Coco Levy, and the COCO levy cases. And definitely, Your Honor, there is a wide variety of cases in the Office of the Solicitor General. Not one case I could remember was treated differently from the others. As an advocate during my time, Your Honor, I have always perceived that all cases are important. Insofar as an applicant for a land registration case is concerned, that particular case is the most important to him. And I do not devote less time to cases like that than other cases of far-reaching implications. So maybe the court, Your Honors, can take notice of the fact that the OSG represents the government in all proceedings, as well as in other matters pertaining to national interest.
Now, the President recently declared his wish that ordered that the Manila Bay be cleaned. Are you aware of that?
Yes, Your Honors.
Under Section 9 of the Solid Waste Act, the DNR is allowed to have visitorial powers.
Yes, Your Honors.
Is it allowed under our present Constitution? I mean, does it need to have a search warrant before exercising or implementing said provision?
Your Honors, in my recollection of the constitutional rights against unreasonable searches and seizures or the privacy of any individual, when we talk of visitorial powers, it pertains to any place or entity that is not being used as a dwelling. The use of any private property, especially in engaging into a business, is always subject to reasonable regulation. The visitorial power mentioned, Your Honor, in the DENR has nothing to do with the intrusion into the privacy of a home. So, to cap my position, Your Honor, the visitorial powers pertain to the places where commercial establishments or any other place which does not constitute as a dwelling place of an individual.
I mean to say that the visitorial powers are not applicable to private dwelling places.
If it is, yes, if it is a home, Your Honor,
You have to seek the permission of the court.
insofar as houses, Your Honors, are concerned.
But suppose the house is at the dwelling place or the house is contributing to the pollution of the Manila Bay.
They can
What
visit,
would
but
the DNR do?
yes, Your Honors, maybe there is a reasonable regulation to that effect. But intruding to the privacy of the home, entering into the bedrooms of the dwellers, to me, Your Honor, is something that must be looked into. If it is being utilized for a commercial purpose, that is going to be a different question, Your Honors.
I'm just referring to the home or the private
Yes, Your Honor. The
dwelling
vicinity,
places.
Your Honor, I suppose that can be the subject of a visitorial power of government agencies.
If the facility or their generators, recyclers, or other facilities are in the yard of the home of an individual, can the DNR exercise its power?
I submit, yes, Your Honor. That is basically part of the function, rather the power of the DNR to ensure compliance with environmental laws.
It is not part. The yard is not part of the private dwelling place.
Yes, Your Honor. Even if
Not
it is part of the private dwelling place, we are referring to the generators, Your Honors. The sanctity of the home I'm referring to pertains to the actual dwelling place where the family may stay.
Well, Section 9 states that this section shall not apply to private dwelling places unless the visitorial power is otherwise judicially authorized.
When I get lucky enough, Your Honor, to be in the Supreme Court, maybe I can make some clarification.
I see. When you were are you familiar with the Genuino versus De Lima case?
Is that with respect to the hold order, Your Honor?
Yes, yes.
Yes, Your Honor,
Because
somehow.
I know you came from the OSG and you are very much well-rounded. Oh.
I hope I will not disappoint you, Your Honors.
What is the main reason for the decision? Or what is the decision in that case?
I distinctly remember, Your Honor, that the state has actually the right to ensure an effective prosecution on the part of the state. So much so that a provisional hold order may be allowed just to ensure the effective prosecution of cases. What is, to me, salient in that jurisprudence is to the effect that the right to prevent the departure of an individual must come from an order of the court. So apparently, Your Honor, an executive branch of government, referring to the Department of Justice, does not have that absolute authority to stop the travel of an individual.
What was the main reason given by the court?
If I remember, Your Honor, it is simply consistent with the right of the state for an effective prosecution of criminal violators. And in fact, I understand the court even cited certain provisions of law to the effect that the right to travel is not actually absolute, and that there are even other salient provisions of other laws that actually restrict anyone's right to travel.
Give me at least 5 statutory limitations on the right to travel.
I understand, Your Honor, that there is a provision on the is that the Human Security Act, Your Honor, passport, the immigration, the inter-country adoption, also with respect to OFW, the workers, Your Honor, who are traveling abroad on supposed to be for a job employment.
You are aspiring to be a member of the Supreme Court where the bangsa, the ball is being questioned. Coming from the OSG, do you know the meaning of decentralization?
Yes, Your Honor.
Defined in Pimentel versus Aguirre. I believe you're familiar with that coming from the OSG.
I have some recollection, Your Honor. But the decentralization, I distinctly remember, is that there is going to be no abdication of the sovereign rights of the state itself. There may be certain functions that may be allowed during the decentralization of this government. It is similar to situations where there is this autonomy of local governments. It pertains to certain provisions on the local autonomy of governments with respect to legislative and certain executive functions. But insofar as, let's say, foreign affairs are concerned, national defense or security, that remains to be the subject of a function or the responsibility of the national government.
There are two kinds of decentralization or devolution. What are those two?
I cannot seem to remember the concept, Your Honor. If I may be given one, maybe I can remember the other.
Okay, one is decentralization of administration. What is the other?
Insofar as the administration is concerned, Your Honor,
You
I'm sorry.
said if I will mention one, you will know, you can answer the other. I said one is decentralization of administration. Now, what is the other?
For this time, Your Honor, I'm sorry, I cannot remember.
Anyway, it's decentralization of power, decentralization of administration, or decentralization of power.
Thank you for that, Your Honor.
May time pa ba ako? This you can easily answer because you said you have been handling cases for the government. In a judicial reconstitution case, the government failed to file an opposition in the lower court. Thereafter, a decision was rendered granting the petition for reconstitution. Thereafter, the government, through the OSG, questioned the decision via an appeal. The petitioner opposed the appeal on the ground that the government failed to file an opposition. How would you rule on that?
Your Honor, in the first place, a reconstitution of title carries with it the burden on the part of the petitioner to show compliance with all the requirements of the law. When the government files an appeal on a question involving titles, Your Honor, the question, Your Honor, will always be whether or not is the government is stopped from any mistake or omission of its officers. It has always been basic and always invoked by the Solicitor General that the government is never stopped from questioning any action that is illegal or improper, as the government or the state is never bound by the concept of estoppel.
So the state cannot be stopped by the omission, mistake, or error of its officials or agents.
Yes, subject to certain exceptions that I have also encountered.
Okay. Now, A filed the petition for reconstitution of a lost title. After the petition was granted and became final and executory, A immediately sold it to B. Thereafter, C appeared with the owner's duplicate title, claiming to be the real owner as he was the real registered owner, and moved for the annulment of the judgment allowing reconstitution. Can the judgment of reconstitution be annulled?
I suppose, Your Honor, that is now going to be a conflict between two titles, the earlier title and the later title. So the question would no longer involve the involvement of the OSG, but the controversy would now revolve on which between two titles would prevail.
Can be claimed that he was an innocent purchaser in good faith?
Depending upon the facts, Your Honor, but irrespective of whether or not he is an innocent purchaser for
It
value,
was immediately after the reconstitution.
yes, even
the
assuming, Your
judgment
Honor,
became final.
I see, Your Honor, it is my humble position that the transferee simply steps into the shoes of the transferor. And in situations like that, again, the only issue is whether or not which between two titles should prevail, the older one or the one that was presented by the transferee.
Yes. Suppose the reconstitution judgment was annulled.
Was
Annulled. And it was already sold to B.
so with more reason, Your Honor, if the reconstituted title has already been annulled, then there is no title to speak of insofar as B is concerned. But I understand, Your Honor, there is also a provision in the pertinent law which would grant him certain remedies. There is the assurance fund, and I understand, of course, that is without prejudice to a claim against the transferor.
With that, I have no more questions. Thank you, Justice. Your excuse.
Thank you, Your Honors. This may not, rather this may be the last time that I will be presenting myself to this Honorable Council. If it will not affect the sensibility of this court, may I approach the Honorable members and Chairman of this Council so that I can extend my appreciation, because at the end of the day, into your hands, I commend my faith.
Your Honors, the last but certainly not the least aspirant for a seat in the Supreme Court to be interviewed today is Honorable Court of Appeals Associate Justice Nina G. Antonio Valenzuela.
Take your seat, please. Good afternoon, Justice Valenzuela.
Honors.
Tony Cayosa will ask the first questions.
Thank you,
Nika
Mr.
Yosa.
Chair. Thank you. Good afternoon, Justice Antonio Valenzuela. This is, I believe, the second time that
Yes,
I
Your
am
Honor.
interviewing you. No?
Yes, Your Honor.
We interviewed you in connection with your application for the position also of Associate Justice of the Supreme Court in 2014.
It's correct, Your
Okay.
Honor.
So since the last time that you were interviewed for the same position, have there been any significant developments in your career as a jurist that you would want to bring to the attention of the court? I mean, the council, rather.
As of the time that I submitted my application for this position, I have zero backlog, and I just found out that my disposition, per my standards, is good enough, and my rate of reversals as well. Because the last time that I submitted, the form did not require the certification from our judicial GRD. But this time, I was told that we had to include that certification. So it is the first time that I found out.
Okay. It may interest you to note that among those who are aspiring for the same position, yours is the second, no, in terms of cases resolved within the past 4 years.
Thank you.
Second highest.
Thank you, Your Honor.
So maybe I can address other concerns
Yes,
regarding your application.
yes,
So,
please, Your Honor.
Yeah, first of all, in your PDS, you divulged that your husband is also a lawyer, but you indicated in his agency or office as NA. Why did you indicate it as NA?
Because he has no agency. He is in private practice, solo.
Oh, so he
Solo
is a solo
practice.
practitioner.
That is
Okay.
correct, Your Honor.
So he doesn't hold office anywhere?
No, he practices from our home office. He has a home office.
Okay, so what type of cases does he handle?
Basically litigation, and then now he does election cases, and corporate litigation, basically,
Are there
mostly.
any other lawyers in your immediate family?
Well, my father was, but he has passed away.
Okay. Now, in your PDS, we also require you to submit or to enumerate if there have been administrative cases. You stated some cases. There
Sure.
was one in particular that we, from the list, obtained from the Office of the Court Administrator, particularly administrative matter number 05-3-159-RTC. This is with respect to the judicial audit conducted in what used to be your court, RTC Branch 28, Manila, where you were granted an extension of 6 months within which to decide 24 criminal cases and 18 civil cases, and you were required to furnish the court, through the Office of the Court Administrator, copies of the decisions in the cases within 10 days from rendition thereof. May we know if you were able to comply with the directive of the court to finish the cases as
Yes.
to be for decision?
May I be allowed to give the background?
Yes, please do so.
When I got appointed to the Regional Trial Court of Manila, when I got there, the particular branch had no records of nothing, no logbook, nothing. Not of the evidence, not of the cases, not of the calendars, nothing at all. No logbook as required. None of the logbooks required in the manuals and the manual for clerks of courts. So I was advised, I went to the Supreme Court and I was advised to request for a judicial audit, not touch anything yet until a judicial audit was conducted. Upon my request, the Supreme Court conducted a judicial audit and there made a list of cases which were supposed to have been submitted for decision years before I had arrived. And so that is the list that you were speaking about. Yes, and because there were a lot of them, plus I also had to do inventory of the object evidence that were in the vault, because the audit team did not deem it appropriate to do it themselves, so they adjudicated it upon my staff and I. So we had to do that aside, and then we had to decide the cases. So I moved for an extension of time within which to decide the cases, and I actually did. We also submitted compliance. However, we couldn't find a copy here, and neither could we locate our receipt of the proof of receipt of the compliance, proof of submission. So my staff and I had to go back to the RTC and check each one, and we submitted the certification attached to the PDS, Your Honor.
So you're saying, number one, that this case arose from a judicial audit that occurred upon your assumption to office and not...
Upon my request, I made a written request.
Okay. Now, so you complied with the
Yes.
order for you to give a list and to
No,
submit
it was the office of the court administrator at that time. It was the Honorable Justice Velasco. He gave a list of because there were no books, so the audit team identified the cases which were already submitted for decision, and they made a list of those that I had to decide, and that is what that list is about.
So you complied with that, the directive, but you have no proof of the compliance.
But now I do, because we went back to the RTC.
Okay. So, but as of today, that particular case, it was docketed.
Which ones?
It's docketed as administrative matter number 05-03-159.
Oh, yes. We submitted the compliance to, I think, the OCAD. We submitted it before like a day after we submitted here, because we were told that it was going to be necessary because there's a portion in the PDS regarding pending cases. So we submitted that. I have a copy.
Are you saying that this was not, this was a case that you initiated?
Yes,
a matter
Your
that
Honor.
you initiated?
Yes, Your
the
Honor.
audit was something that you initiated.
Yes, I requested for it.
But may we know why you did not indicate this in your PDS?
Because I didn't know that I had no compliance. Because I knew, from what I know, and my staff, because I brought some of my staff, we already complied. However, when we asked for a certification from the OCAD, they said I had a pending case. And when we asked what it was, they said this. And then they said, but I said we already had complied years ago. In fact, I wouldn't have been appointed to the Court of Appeals if I had not complied and decided all the cases listed. And then they said they have no record, and neither could I produce. So what we did, I sent staff, my two members of my staff, to go to the regional trial court, and we looked for all the cases one at a time, and we found all of them. And so the RTC issued a certification that the cases have been decided, and we submitted the certification to the the OCAD, Your Honor.
Okay, so thank you for your explanation, Justice. We will take that into consideration because without that explanation, that would really be considered as a pending administrative case, which would otherwise render you disqualified. So we will have to find out how we would characterize, no? So in other words, these cases have already been resolved?
Right, even like, because I was 5 years in the regional trial court, my first year, they were finished already.
Solved.
Yes, Your Honor.
Okay, anyway,
So I was not aware that there was a pending case. I was not only now when we applied this second time, because not when I applied for the Court of Appeals, there was nothing. I was not informed of any such pending case. When I applied in 2014 for the Supreme Court, again, I was not informed of any such pending case, only now. So you were surprised.
okay. Thank you, Justice. Now, let me take this opportunity to accommodate some questions that were sent in by ex-officio member Congressman Liachon.
Your Honor.
Yes, with respect to death penalty, do you think that the current criminal justice system in the Philippines is ready and has sufficient processes to ensure that the penalty of death will only be served to those who are really guilty of the crimes?
Is the question about, may I
In other
ask,
words,
the
you think
judicial
that
process?
that the current criminal justice system, no, would actually be fair, so that the country would be ready for death penalty.
All right. Theoretically, the laws are clear and are fair with respect to the criminal proceedings, and at each step of the way, the rights of the accused is acknowledged. It is so if all the judges abide by the are by the book, apply each provision of law according to how the rules of court is written, I would think that the judicial process with respect to the death penalty would be sufficient, theoretically, Your Honor.
Thank you. His other question is with respect to the proposed bill lowering the minimum age of social responsibility, as he calls it. Do you think that lowering the minimum age of criminal responsibility will actually deter or lower the crime rates involving children in conflict with the law? And how should the court act proactively in protecting the children from adult criminals?
My judicial philosophy is I have to separate my opinions from what the law and the Constitution state. So when I answer your question, it will be it will not reflect my personal opinion. I have been trained that whenever you implement a particular law, there should be a particular provision of law, and you have to apply that particular law to the facts as you see them, as the evidence dictate. Now, so I cannot impose my personal view as to which age would be appropriate to determine social responsibility, criminal liability. So from my legal training, you have to have a legal basis. You cannot just pluck a certain age from thin air and say this is appropriate. So from my readings, the historically the revised penal code put it at 9 years old, and then 15 with discernment, without discernment. Then I read somewhere the United Nations recommends, the word used is recommends 12. But considering also it is a fact that children now would be different from children at the time that the revised penal code was promulgated. And so with the stimuli that the children receive now, I would think they would have better discernment and more maturity at age 9 than children who were 9 at the time of the penal code promulgation. So I would think, but then because of the United Nations recommendation, 12 would be appropriate.
That was my last question.
Thank you, Your Honor.
Justice, and with that, I wish you luck. Thank you.
Thank you.
Thank you, Justice Mendoza.
Thank you, Attorney. Judge Ilaw.
Thank you, Justice Mendoza.
Good
Yes,
afternoon,
good
sir.
afternoon, Justice Nina Antonio Valenzuela.
Good afternoon, Your Honor.
You are now living in Ayala Alabang village, inside or outside?
In the perimeter property, Your Honor. There is only a wall behind my house and Katarungan, so we are on a perimeter property, Your Honor.
So, in your SAL-ends, and even the cash in PDS, 870.34, is equivalent to, with the plus, total of 5,168,000. And SAL-ends again, from 2007 up to 2017, you have 21,626,000.
Yes, Your Honor.
Wow. I didn't receive this when I retired. Where do you attribute this huge amount of assets?
Your Honor, I would like not to be bragging, but I have lived in Ayala Alabang since before. When I was in the MTC, I already lived in Ayala Alabang, so there is not much improvement in my riches. I was raised very frugally. I don't know. According to my husband, I don't know how to spend money. When we were growing up, I did not have an allowance. There was a box where my mother put the money, and you were supposed to get only what you needed. And that she said that if you got more than what you needed, we were going to be poor, and nobody wants to be poor. So that honed my frugality and honesty. I did not get more than what I needed. And so even now, I'm very frugal. I grew up on isang ulam sa isang meal. No desserts, but I'm fat nevertheless. So, but yeah, frugality. And my grandmother says, kailangan matipid lagi kasi hindi lagi kumikita. And my parents are very hardworking, and
How is your 91-year-old mother, Justice Valenzuela?
oh, she is feisty and very intelligent. She knows the exchange rate every day. She knows how much property rates per square meter are in different places because she likes to read the newspaper. And she's probably watching now. And Yes, she is very intelligent.
She's watching now. Is this a threat?
Exactly why I'm nervous.
And how much of your time are you able to spend with her?
Exactly. Your Honor, I used to teach. However, she waits for me. She didn't used to wait for me. I don't know. In the recent years, she'd wait for me, and she wouldn't sleep. But my classes were in Manila or in Makati, and they'd end at 9, and sometimes I get home 10:30, and she's still up. So I decided I will not teach anymore, and so I can spend time with her. She likes to talk about the current events and economics and business.
What is the most difficult challenge you have faced on your career as a Court of Appeals Associate Justice?
I always tell people, this career we went to school for this, so all the substantive matter we already know. We try to practice what we read and learned. But obviously, in law school, we were not taught about how to deal with people. That is the greatest challenge that I am always faced with, even in the Court of Appeals. It's the litigants and the people.
What did you learn from it?
Things pass when they talk about you in the newspaper and you feel not good. As long as you go by the book, if you went by the book, observe the Constitution and all the laws, they cannot turn things. And so after a while, things will be quiet and your work will be seen as it is, having implemented the law according to its letter.
And what do you consider your greatest failure in your career or in life?
I took the bar twice, but then there's a redeeming value in it. I learned that I'm not very smart as I thought I was. I learned to work harder, and I learned that the world is kinder.
You took the bar twice.
That is
Why
correct.
should you be chosen from among other applicants
Um,
who took the bar but once?
I will respectfully respond, Your Honor. The bar is not the only measure of one's competence, and I would think that my record as a member of the judiciary has proven that I have the competence, integrity, probity, independence, and judicial temperament that is necessary for the job. So the bar would be my past, but definitely part of my permanent record, Your Honor.
You have no litigation experience whatsoever, am I
None, sir.
correct?
Yes, sir.
Would you suggest this career track to young lawyers who aspire to join the judiciary?
I've thought of that already, the fact of my having no litigation experience. However, when you are a law clerk, in fact, from the time I started with in the Supreme Court with Justice Amarfina Herrera, there was a chance to see everything, even if it was not in the actual trial court. If one is diligent, you read the page by page of the transcript and all the records, every page. I read every page. And so by 6 months, it was like I had litigation experience, although it probably is vicarious. But nevertheless, it taught me the skills that would be necessary for a litigator.
some of these SALNs you submitted to the council appear to have no as of dates. Do you think this is immaterial so as to leave it blank?
Because I'm not very meticulous in documentation. However, at the lower portion, Your Honor, there is an indication of the date when it was submitted. So, although, yes, I now understand that I should, from now on, put the as of date because yes. I too got confused when I was fixing my PDS because there were no as of dates.
You spoke about judicial temperament earlier.
Yes, Your Honor.
How about what is this judicial, the doctrine of judicial restraint? Judicial restraint.
Restraint. Okay. That is what I practice. My judicial philosophy. Judicial restraint means that in interpreting the laws, you only use the Constitution and stare decisis. There is no leeway given to a member of the judiciary with respect to other opinions, personal, as I stated a while ago. So just stick, I call it, I'm by the book. So everything is procedural and everything is according to the Constitution and according to the rules of court. Thereby, there's stability, uniformity, and clearness of all the proceedings, Your Honor.
Do you recall the case of Estrada versus Escritor?
I am not familiar, Your Honor.
Anyway, what is the benevolent neutrality approach on the Constitution's religion clauses? Sorry,
I'm sorry, Your Honor. Religion
clauses
clauses.
that with respect to the benevolent neutrality approach on the Constitution.
The Constitution recognizes the Constitution demands equal protection of the laws and gives religious freedom to all persons. So I would think the practice of religion cannot be controlled by laws.
About this in Lagman versus Senate President Pimentel, chair number 235935, February 6, 2018. Do you know the ruling of this court, the Supreme
I'm
Court?
sorry, I am not familiar, Your Honor.
About the doctrine, what is the policy of accommodation with regard to the right of freedom of religion?
Again, the Constitution allows freedom of religion to every citizen. And so the practice of religion should not be curtailed. Our religious beliefs should be respected.
Does the administrative jurisdiction of the court over a court employee apply before or after the employee's appointment to the judicial branch?
I'm sorry, Your Honor. Can you please repeat the question?
Does the administrative jurisdiction of the court
This court.
over a court employee apply before or after the employee's appointment to the judicial branch? This is in Oka versus Ampong. Administrative matter.
The court.
No. Yes, please.
The Supreme Court has has administration over an employee once he is appointed I don't think the court can have judicial administration over an employee who is before he is appointed.
All right, the court says that the bottom line is administrative jurisdiction over a court employee belongs to the Supreme Court, regardless of whether the offense was committed before or after employment in the judiciary. All right, that was my last and final question. Thank you for your time, Justice,
Thank you, Your Honor.
and good luck.
Salamat po, Your Honor.
Thank you, Judge Ilaw. Justice Valenzuela. In Laconia, New Hampshire, a law was passed regarding indecent exposure. It bans sex and nudity in public, but singles out women by prohibiting the showing, quote, the showing of female breast with less than a fully opaque covering of any part of the nipple. 3 women who are members of the Free the Nipple campaign, a global campaign advocating for the rights of women to go topless, were arrested after removing their tops at a beach in Laconia and refusing to put them on when beachgoers complained. One was doing yoga while the others were sunbathing. A lower court judge refused to dismiss the case, and the women appealed to the state Supreme Court. The state Supreme Court upheld the conviction of the 3 women who were arrested for going topless on a beach, finding their constitutional rights were not violated. The court decided that Laconia's ordinance or law does not discriminate on the basis of gender or violate the women's right to free speech. It wrote that the generally upheld laws that prohibit women but not men from exposing their breasts against the equal protection. No, they cited the other courts, cited the other decisions of the courts which generally upheld laws that prohibit women but not men from exposing their breasts against equal protection challenges. In 2017, a federal judge ruled that a public indecency law in Missouri didn't violate the state constitution by allowing men but not women to show their nipples. In 2013, a public nudity ban in San Francisco was also upheld by a federal court. The ponente wrote, "We have found that the ordinance does not violate the defendant's constitutional rights to equal protection or freedom of speech under the state and federal constitutions. As such, it does not unduly restrict the defendant's fundamental rights." So it agreed with the trial court. In the context of the Philippine Constitution, how would you have ruled on the case?
As a general rule, Your Honor, the Philippine Constitution mandates that there shall be equal protection of the laws. Therefore, you're not. However, if there are reasonable classifications, then there could be a curtailment, or there could be review of certain provisions that would seemingly disturb the doctrine of equal protection of the laws. In this case, if there was a law that would prohibit prohibit the exposure of women's nipples in public places, I would rule. May I say also that the interpretation of laws by courts, interpretation of laws and the Constitution by courts is not in a vacuum, because the Constitution is not in a vacuum. So it should be in tune with the times. So whenever one writes a decision, it should, if it is read in different times, maybe 10 years, 20 years, it should be read with the milieu of the date when it was written, because the Constitution is moving and not static. So with that, I would rule that the prohibition does not curtail the right freedom of expression of the women, because there's a difference between men and women. Women's breasts give nurture and nourish children, whereas men's mammary glands, although they do have the same mammary glands, do not serve the same purpose. For that reason, it would be fair to have a law that would prohibit the exhibition of nipples, of female nipples, Your Honor.
So, you would not rule that it is unconstitutional because it treats men and women differently?
The classification is reasonable, and it acknowledges the different purposes of the male mammary gland and the female mammary glands.
So it does not amount to sex discrimination.
I do not think so, Your Honor. I am not.
Of the mammary glands of females in public places. So you agree with the ruling?
Yes, Your Honor.
That because in your letter to the Chief Justice, you said you received in 2012 the APO Oblation Run Award. What can you say about the APO Oblation Run?
That is
Is it
tradition.
violative of the revised penal code on obscenity? Or
It is a tradition, Your Honor, and it is symbolic of the freedom, academic freedom. Hence, it depicts the oblation statue. So that it is not. I would think that is not obscenity that is violative of the 1987 Constitution.
what is the test of obscenity?
Obscenity is when it is presented, it would cause prurient responses to persons to whom it is shown. And what is prurient to one would not be prurient to others.
So, about the community interest.
If there is if the material has a specific and identified purpose, the response of a community, although may be different from the purpose for which it was originally set, would not make it violative of the Constitution.
In jurisprudence, there were two cases in the U.S. which were adopted in the Philippines. One was the Roth versus United States. Do you still remember that?
Roth?
Yeah, the test for obscenity
No,
in
Your
the
Honor.
Roth case.
No, Your Honor.
There. How about the Miller versus California tripartite standard? What are the three
I'm not aware, Your Honor.
criteria?
For obscenity?
Yes.
I cannot recall, Your Honor.
Anyway, Miller has already revised Roth's emphasis on creating a uniform federal standard. Instead, it touted reliance on community standards of a more local nature. So, the tripartite standard established by Miller, the following are the criteria. One, whether the average person applying contemporary community standards would find that the work taken as a whole appeals to prurient interests. Two, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. And whether the work, three, whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. That is the test. Applying this test in the APO oblation run, what can you say?
I do not think the three elements that you mentioned are applicable because when the fraternity brothers run, it is not to be taken as sexual, neither is it for prurient imaginings, because when they do that, they are extolling they extol the ideas of economic freedom, freedom of expression, and in essence, a free citizen, hands outstretched, and yes, the organ also exposed. I do not think the three elements would be present, Your Honor.
Diliman, two unidentified naked women were seen tailing 30 members who were part of the event. Why this was condemned by APO? Why do you exclude women in the oblation run?
Because as I already said, it is done in UP, and UP has the oblation, and it is symbolic, and the symbol of UP is a male figure. It is unnecessary for women, and it is unnecessary, and it is not the symbol. It is not the symbol that the fraternity has chosen. So it will not serve a particular purpose if women also ran with the men.
There is no sexual discrimination there?
I don't think so, Your Honor,
Okay.
because the purpose it would be.
In 2012, you were a recipient of the Apo Oblation Run Award. Did you participate?
No, Your Honor.
No.
This
How was that? Why were you awarded?
it's for excellence, Your Honor, because the chapter of the Alpha Phi Omega is a worldwide organization, college organization. The chapter in UP is called ETA, and ETA is for excellence, and the award is for excellence. Perhaps
So-
they found
So the Oblation Run Award is not only limited to those who participated.
it is for to recognize excellence, Your Honor. Not running.
You are not yet a senior citizen. You are only 55, right?
55 last
55.
December, Your Honor.
You're not yet a senior citizen. The senior citizen law mandates giving 20% discounts to senior citizens relative to the utilization of transportation services, hotel, restaurants, drug companies, etc. In effect, it raises the prices for those who are not senior citizens like you. Is this not violative of the Equal Protection Clause of the Constitution?
No, Your Honor, because there's a reasonable classification. All persons who are of that age would enjoy the same privilege, and that is also consonant with the Constitution's protecting the lives of its citizens.
Because the establishments raise their prices, you are affected. You're not a senior citizen.
I don't think, I'm not sure, I'm not aware if the
Because
establishments,
they raise their prices to compensate for the discount.
I don't think so, Your Honor, because when I
You don't
buy
feel it.
medicine,
You don't feel it.
when I buy medicine for myself and for my mother, the price tag is the same, but she gets the 20 off and I don't. But there's no rise in the, I'm not an economist, I wouldn't know. The price tag would be the same, Your Honor.
The basis of the senior citizen law. Or what is, yes, what is the constitutional basis?
The Constitution shall afford good life, protect the lives of its citizens, ensure medical health and medical, no, health and prosperity. Save money.
A justice of the
health.
Supreme Court argued that there is taking from the establishment, and therefore it is an exercise of the power of eminent domain because of the taking. Do you agree?
Taking from the establishment.
Yes, yes. he considers the take the 20% discount as taking from the establishment, and it should be upheld on the basis of the power of eminent domain.
Perhaps it would be more appropriate to cite the police power of the state because for the welfare of the senior citizens, because if it were eminent domains taking private property for public use for with just compensation, I would not think that is eminent domain. It's more of police power, the exercise of the police power of the state, Your Honor.
Okay. Recently, the President ordered or directed the clean-up of the Manila Bay. Under Section 9 of the Solid Waste Act, the DNR is allowed visitorial powers. Does it need to have a search warrant first before implementing the provision?
Or is this the particular case of the Manila Bay, or is the question
Oh,
in general?
in general.
Because the Manila Bay has
Solid
already
Waste-
a decision.
Solid Waste Act. Yes, there is already a decision
So
regarding
there's-
Manila Bay. Section 9 of the Solid Waste Act regarding the visitorial power.
I would think there is no violation of the Constitution if there is no search warrant because it is the exercise of the state's police power for the general welfare to clean up the Manila Bay.
When shall it not be allowed, the visitorial power?
If it's if it is, it would be a violative of the Equal Protection Clause if it only if the statute or provision specified a particular group, let's say just restaurants or just hotels. But if it does not specify, and then it could cover all establishments, then I would think it is not violative of the Equal Protection Clause of the Constitution.
Section 9 says it does not apply to private dwelling places.
But
That unless the visitorial power is otherwise judicially authorized. Anyway, with that, the interview. But that was my last question.
thank you, Your Honor.
Your excuse. For the record, the interview is for today is concluded, terminated.